So they talk of the marginal note that I was reading. And that's the language of 368 to our mind is plain and unambiguous, that paragraph. The bottom of 620 minutes.
Yes, Mr. Zubin.
But I was reading, marginal note plays a very little part in the construction of a statutory provision. It should have much less importance
620.
in construing a constitutional provision. The language of 368 to our mind is plain and unambiguous. Hence, we need not call into aid any of the rules of construction about which there was great deal of debate. The marginal note as a power to amend under the article, as it originally stood, was only implied. Language of 368 to our mind is plain and unambiguous. Paragraph. Reference to the procedure in the marginal bottom of 620 the existence of the power implied in the article. Then they go on to say whether you can amend little part of the construction of a statute, it should have much less importance in construing a constitution. Now kindly come to paragraph. The language of 368 to our mind is plain and unambiguous. Hence, we need not call into aid 424 any of the rules of construction about which there was great deal of 24. This is the judgment of Justice Jagan Mohan Reddy, as it originally stood, was only implied. The marginal note rightly referred to the procedure of amendment. Reference to the procedure paragraph of the marginal 1117 negative the existence 424 implied in the article. Then they go on to say whether you can amend every part of the constitution. Reference is made to Dr. Ambedkar's the basic structure theory, so we're not concerned. Now kindly come to paragraph. Very interesting observation. 1117.
424 you said.
That's a 424 PDF. 424. Paragraph 1117. 424. This is the judgment of Justice Jagan Mohan Reddy. Paragraph 1117, page 424. The question arose in the context that when the Constituent Assembly is sitting, where reference is made to Dr. Ambedkar's this constitution by majority vote. And this is an unelected observation. When you give that part of the Constitution, why do you need 424 PDF? So that paragraph 1117. Dr. Ambedkar answers that. Lordship has 1117?
Yes.
My Lord Justice Gawai, Justice Kaul. Yeah. Reference may also be made to the fact that during the debates in the Constituent Assembly, it was pointed out that arose in the context that when the Constituent Assembly did not represent the people as passing this inherent constitution by majority franchise. And some of them even unelected, suggesting that the Constitution when you give that part of the Constitution, why do you need both the claims and demands were rejected? That Dr. Ambedkar explained that. Dr. Ambedkar answers that. The Constituent Assembly, in making a constitution, has no partisan motive.
Yes.
My Lord Justice Gawai, beyond securing a good and workable constitution, reference may also be made to the fact that during the debates in the articles of the Constitution, it was pointed out that by many speakers getting through a particular measure. That assembly did not represent the people as such because it was not elected on the basis of adult franchise. Members and some of them even moved resolutions suggesting that the Constitution seeking to carry amendments to the Constitution. Both the claims and demands were rejected. Dr. Ambedkar explained passing of particular measures the Constituent Assembly in making a constitution by reason of some has no partisan constitution. Beyond securing the Constituent Assembly and workable constitution has none. It has no axe to grind. That is the difference. Considering the articles of the Constituent Assembly has no eye on getting that explains why the Constituent Assembly, though elected on limited franchise, met as a constituent to pass the Constitution by simple majority, will be why the Parliament, though elected on adult to carry amendments cannot be trusted with the same power to facilitate. How prescient was of Dr. Ambedkar to passing of particular. So when you are actually trying to use Parliament by reason of some article of the Constitution. Then you do it with the Constituent Assembly because you want to get a bill passed, you want to get a particular policy through. That is the difference between the Constituent Assembly and future Parliament. You have no such motive. That explains why the Constituent Assembly, though elected on limited franchise, so you can't convert a legislative assembly into a Constituent Assembly. And why the Parliament, though elected on adult suffrage, cannot be trusted because as a legislature, how prescient was of Dr. Ambedkar. Intent may be partisan. So when you are actually trying to use, it can't be. Well, you're not passing legislative power, then you do it with a partisan. At the final stages of the debate on the amending article, Dr. Ambedkar, replying to the objection that the Constituent Assembly was not a representative Constituent Assembly, you have as it has not been elected on adult franchise. That a large mass of the people convert a legislative assembly into a constituent assembly. And consequently, in framing the Constitution, the Assembly has no right to say that the Constitution should have as a legislature, which Article 304 proposes to give it. Intent may be partisan. Said, sir, it may be true Constituent Assembly that this Assembly is not a representative assembly in the sense that members of the Assembly have not been elected on the basis of the final stages of the debate. I'm prepared to accept that argument. Dr. Ambedkar, replying to the objection that the Constituent Assembly was not a representative. The Assembly had been elected as it has not been elected on adult franchise. It was then bound to possess greater wisdom and greater political that a large mass of the people are not is an inference which are and consequently in framing the Constitution, the Assembly has no right to say that the Constitution should have the finality which Article 304 proposes to give it. Now kindly come to Quello. It may be true Volume this 3. Assembly is not a representative assembly in the sense that members of the assembly on the other end, the have not been elected on the basis of adult suffrage. I'm prepared to accept that argument. Yes, yes. But the further inference which is being drawn that if the assembly had been elected on the basis of adult suffrage, it was then bound to possess greater wisdom and greater political knowledge is an inference which I utterly repudiate.
Stated here and what is the objective and purpose.
Then, Malas, that's enough for this part of the
there is
discussion.
An element of flexibility.
Now kindly come to Quello.
Let's not go into the
Volume
specific
3.
how it was done in this particular matter.
On the other hand, the Constituent Assembly of State of Jammu Kashmir was elected.
Yes, yes.
I'm saying on the rationale.
That's right.
It should or should not be.
That's right.
It's simple. There's slight difference between Article 370 and what is stated here and what is the objective and purpose in the form of whether it's consultation. There is an element of flexibility in 370. Let's not go into the facts, acceptance, how the incorporate and become part of this particular matter. So when we read the proviso to clause 3, at the time when the Constitution was adopted, obviously there was no Constitution of J&K.
No Constituent Assembly.
And no Constituent Assembly. But obviously they were aware that Constituent Assembly is going to be to come up and going to do it in the form of. So why can't we, when we consultation the or with because prior, if we accept the argument that clause 3 is not incorporated, was not to become after the Constituent Assembly this. So when we read they had the proviso to clause 3, why can't we accept at the time when the Constitution was adopted? Obviously, there was no Constituent Assembly for the purpose of the proviso.
No Constituent Assembly.
Good and no Constituent Assembly. But obviously, they were aware also to include the Legislative Assembly, keeping in mind the fact. So why can't we, when we interpret the Constitution, because if we accept Parliament could have very well amended the was not to become dead after the Constituent Assembly had enacted or except they had proposed the Constitution. That if the objective was to, why can't we accept that argument? Was not to close the Constituent Assembly for the purpose of the proviso. Put Article 370 in a straitjacket, which is obviously clear. It's a flexible interpreted also to include the Legislative Assembly, keeping in mind D or the fact it's B1 or B2. You could keep on. Parliament could have the very well amended the Article 370 also.
That's nothing to do with 370 sub-Article 3. There's no flexibility there. Where's the flexibility?
So it is incorporated in 3. If the objective was to, if we accept the, it's incorporated in 3, that notwithstanding anything contained in the foregoing provisions of the article, the President may with public notification declare the article will cease to be operative or shall be operative only with such exception modifications from such date as it may specify. B1 or B2. The proviso puts keep on adding up to it and the orders pass.
No, it's a flexibility at the instance of the Constituent Assembly. That's nothing to do with the instance of Article 3. There's no flexibility there.
But
Where's
then,
the
when
flexibility?
we are
So
reading
it is
the term
incorporated into
constitution
assembly for the
assembly,
purpose of
if
the
we
proviso.
if we
At
accept
that time when it was
it's
enacted,
incorporated
it was
in
in
1949,
But they
that
contemplated it,
notwithstanding
Manoj.
anything contained in the
They
foregoing
contemplated
provisions of
it.
the
Why would they
article,
add the word
the
Constituent
president may
Assembly
with
in
public
370 when it was
notification
not
because
in
at
the
that
article?
time we didn't have any legislative assembly for the
or
state
shall
of
be operative only with such
J&K.
exception modifications
No, correct,
from
but you
such
have the
date as
orders.
it may specify.
Yes, the proviso
Well, I
puts
don't
an
understand.
puts
The
a
flexibility at the
precondition.
instance of the
No, it's a
Constituent Assembly,
flexibility at
but
the
this
instance
power
of
is
the
given to the
Constituent
Constituent
Assembly,
Assembly, not to the legislature. Surely, Malak.
But then,
It's not
when we are
flexibility at the
reading
hands
the
of
term
Parliament
Constituent Assembly for
or the
purpose of
legislature, because
the
147
proviso,
says there's no
at that
flexibility
time when
there
it
at
was
all.
enacted, it was in
But they
1949.
contemplated it, Malak.
So there are two parts to
They
it.
contemplated
First
it.
is
Why
whether
would they add the
Parliament
word
could have done
Constituent
it, that's a
Assembly
separate argument.
in 370 when
But
it was not
because
in
at
there?
that time we
interpret
didn't
the
have any
term
legislative
Constituent
assembly for the
Assembly
state
for the
of
purpose of the proviso to clause
J&K.
3. Can
No,
we,
correct,
by
but you have the
implication, because
orders.
at the time when the constitution was
Well, I
enacted,
don't understand. The
at that
flexibility at
time
the
there was
instance of the
no
Constituent
legislative
Assembly, but
assembly
this
for the
power is
state
given to the
of
Constituent
Jammu and
Assembly,
Kashmir.
not to the
Is that factually
legislature.
correct? Answer is yes.
Yes, of course.
So
It's not
then,
flexibility at the
when we
hands of Parliament
interpret the term over
or the
here,
legislature,
can we
because
interpret
147
it
says
to
there's no
include the
flexibility there at
legislative
all.
assembly?
But Manas, how can you interpret a term in a
there are
constitution
two
which
parts
says
to it.
Constituent
First
Assembly
is
as the
whether
legislative
Parliament could
assembly? I
have
don't
done it, that's a
understand.
separate
Manas.
argument.
Under what
But
concept of
When we
interpretation of the
term
Constitution will you do
Constituent
that?
Assembly for the purpose of the proviso to clause 3,
There is no implied power.
can we by
There is no
implication,
express
because at
power.
the time when the constitution was
I mean, you can
enacted,
change any definition of any
at
given
that time there was no
That may
legislative
not be- that
assembly
will
for the
be a-
state of
Look,
Jammu and Kashmir. Is
the
that
term
factually correct?
Constituent
Answer
Assembly,
is
when
yes.
it is used
Yes,
in the
of
proviso
course.
to clause 3,
So
at
then,
that time,
when we
at that time,
interpret
there was
the
no
term over
legislative
here,
assembly
For the
can we
purpose of
interpret
framing the
it to
Constitution that the
include the
Constituent
legislative
Assembly is
assembly?
formed. But Manas, how can you
That's not
interpret
Manas,
a
there's
term
nothing
in
to
a
do with the
Constitution which
Which
says
is why,
Constituent
Manas,
Assembly as the
segregation and
legislative assembly? I don't understand, Manas.
See,
Under
the
what
explanation which has
concept
been
of interpretation
enacted
of the
was
Constitution will you do
afterwards,
that?
is sometimes in 1952.
There is no implied
Explanation
power.
Acted
There is
and
no
has
express
been made
power.
part of part 1.
I mean, you
clause
can
1.
change any definition
was
of any
probably in
provision of
1952,
the Constitution.
if I'm not mistaken. That may not be, that will be a,
It was there, Manas.
look, no. The term
was
Constituent
amended
Assembly, when it
later on.
is used in the proviso
That's
to
not,
clause
it was
3,
there,
at
but
that
fine.
time.
It was
there, it was
at that
amended.
time
Yes,
there was
yes.
no legislative
Because
assembly.
at that time,
purpose of
when
framing the
the
Constitution that the Constituent
legislative
Assembly
assembly
is
was
formed.
brought in.
That's
Council of
not, Manas,
Ministers
there's nothing to do
was
with the
brought in.
legislature.
Because
Which
at
is
that
why,
time there
Manas,
was no
Segesham Bharti.
was had to be.
See,
There
the
was no council
explanation which has been
ministers at that time.
enacted
Maharaja Manas.
was
That
afterwards,
issue doesn't
is
arise here.
sometimes
We're
in
talking about
1952.
Manas, a Constituent Assembly, the power of the Constituent
and,
Assembly.
has been
And
made
you've
part
now,
of
there are now the
part 1,
Keshavan
clause
Bharti
1,
Manas,
was probably in 1952.
fortunately
if I'm
and
not mistaken.
unfortunately sets out the law.
Mr. Sibal, just as a, because we are not looking at it from that perspective yesterday, where was the first reference to the Constituent Assembly? Of course, the Constituent Assembly of the state finds a reference in the Constitution itself in Article 372,
Yes.
370 bracket 2. Where is the first reference to the Constituent Assembly in the documents which you read out to us yesterday prior to the Indian Constitution? I find that in the proclamation of the Maharaja,
Manas, they are in the Constitution debates, Manas.
I find that there's also a reference in the proclamation of the Maharaja which we read out yesterday. The reason I'm asking is this:
It's probably there, yes.
Sorry?
Karan Singh's proclamation, I think. Manas.
Yes.
Huh? I've already mentioned that in the Constituent Assembly debates. Iyengar, Manas, your Lordship will remember.
Yes.
I quoted Manas' sentence.
Yes, volume 8,
All there, Manas, yes.
page 117. Yeah, Mr. Gopal Swami
Yes,
Iyengar's.
all there, Manas, yes.
No, because when the Maharaja made the proclamation, when the Maharaja issued his proclamation on 5th of March
It was
1948.
contemplated by the Constitution and the Constitution makers that there would be a Constituent Assembly which would come into place, which happened in 1951.
Right.
That's what happened. Manas.
What happened first was when the Maharaja made his proclamation in 1948, he spoke of a National Assembly.
Yes, absolutely.
Right? He says, my Council of Ministers shall take appropriate steps as soon as restoration of normal conditions have been completed to convene a National Assembly based upon adult suffrage. Then 5, the Constitution to be framed by the National Assembly
Yes.
shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing for the freedom of conscience.
right.
Now, what appears to have happened was that before elections were held, by adult suffrage, they composed the Constituent Assembly. That's how the Constituent Assembly came into existence. Now, your whole argument is, of course, that, what is to be done by a Constituent Assembly cannot really be done by a Legislative Assembly, and therefore less so by the central government assuming the character of a Legislative Assembly under 356. That's the... what happens then if there is no Constituent Assembly?
I'm sorry, Mal?
What happens if there is no Constituent Assembly? Do you have to create a Constituent Assembly afresh?
Well, that is precisely between 1948 consultations.
No, now what would happen? Suppose they keep aside the procedure which they followed. We're keeping that aside for a moment. 373 postulates the Constituent Assembly has to give its recommendation on any proposal for abrogation.
Right.
Suppose the president were to move a proposal for abrogation. According to you, how would that be effectuated now, say in post-1957 India?
Let me answer that in two parts. Number one, what my lord is putting to me is in 1948, they contemplated a National Assembly.
Right.
But your lordships must remember that those were years between 1948 and 1950, especially after 1947, after the Instrument of Accession was signed, Mullah. After the Instrument of Accession was signed, those were transitional periods. And when the Constitution came to be framed, there was a dialogue between the state of Jammu and Kashmir, as it then stood through the Maharaja, and the government of India. And both of them decided that we will put this into the Constitution, that is 370, use the term Constituent Assembly, and you will then set up a Constituent Assembly to frame the Constitution and decide what you want to do. You must understand the historical context in which this happened. This has not happened in an isolated fashion. The Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K Constitution contemplates that this Legislative Assembly will have no role in regards to the amendment of the provision of the Constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of a...
Next question is, supposing there was no Constituent Assembly. That's the next
question. How do we, then what constitutional mechanism would be envisaged then?
If there were no Constituent Assembly and your lordships were sitting in 5, I would answer that question, but luckily we have a Constituent Assembly. Because I can't answer a hypothetical question as to what would
how would you then put into place the constitutional machinery? Because there has to be machinery. It can't be that, because there is no Constituent Assembly, because there is no Constituent Assembly, you cannot at all deliberate on a proposal for abrogation or modification of Article 370.
Your lordship is putting to me, supposing the Maharaja refused to have a Constituent Assembly.
No, take 2019.
I'm sorry?
Take 2019.
Yes.
When the Constituent Assembly has been convened, the Constituent Assembly has drafted the Constitution.
Yes.
Therefore, its role has come to an end. There is no Constituent Assembly.
Correct.
2019. The government wishes to, the president wishes to modify Article 370.
Yes.
Now, we've seen the process which they followed.
Yes.
What, according to you, would have been the constitutional process to...
No constitutional process, because the Constitution of Jammu and Kashmir said, in terms in 147, that no such bill can be introduced in the legislature.
Oh, by them?
By them.
I'm talking about, no, by them, where the Constitution as it applies to the state of Jammu and Kashmir, which is part of the law applicable in Jammu.
So, according to you, no constitutional procedure can be initiated for abrogation of Article 370 at all.
I've been saying it's permanent. Why do you, Mullah, I've been
The argument is that after 1957,
yes,
the president ceased to have any power under Article Article 3 of Article.
That was temporary between 1951 and 1957. Where do you get that power from? You see, the point is, Malaj, at that time it was temporary because there was nothing in place.
After 1957, sub-Article 3 has become odious now.
Yes, no, Malaj. It can happen as a political decision. The Jammu and Kashmir government and the legislature of the state unanimously did what, and they merged. That's another issue altogether.
So, Mr. Sabal, according to you, neither the assembly can do it,
Yes,
not the parliament can
yes,
invest.
yes.
What you are saying is, while other provisions of the constitution may be capable of amendment through a process envisaged for amendment,
Yes,
other than, of course, if it is hit by basic structure,
correct.
this is one provision which can never be amended.
Well, and let it put it differently, but let me put it, under what power will this take place? Let's assume Manoj can do it. If my lord
I'm just
put the
thinking
question to
aloud,
me,
to have a
under which provision of the constitution can they do it?
Having a permanency, the whole concept is that constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically
Then
saying,
a political act can be, but there can be a political act.
And,
What can be the
those negotiations,
Clause 1 is the answer to this. 370 clause 1, bit by bit modifications, exceptions, applications have come. Now, if, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can
modifications.
Parliament not have amended the constitution exercising the 368 power to abrogate 370?
No.
Which means therefore that there is a provision of the constitution, apropos what fell from Brother Justice Call, that according to your submission, there is a provision of the constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note
So we are creating then a new category apart from basic structure.
No, not
That 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is it-
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, is now, it cannot be.
not done.
want to put
Yes.
is that 371, according to 370 sub clause 1, itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the constitution applies to the state of Jammu.
Yes.
Then what remains of 370?
Nothing.
Then the only,
To say that you can,
It can
in
be
a
taken.
sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So I'm
1.
saying therefore said that
Yes.
371, according to you,
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the
It
constitution.
can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are
be.
saying that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I'm.
This is what we are saying.
Yes, Mr.
That-
Yes.
That may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that will, I think, Mr. Sankarnaran, what will happen is, we are following a certain line and a link and a syntax, so, I mean, I think, we might be broken up in the nuance of.
Because, respect Mr. Sibal, he knows the law. We also therefore didn't jump and answer the questions.
I don't think.
See, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi
can.
said, no, this is not what I'm saying something different. So we'll have to see where the call, right?
You can't
I
say
understand. So
something
your
different,
argument,
no
I've
issue at all.
understood at your own turn. He says that you can keep the shell, but the process is to 370 and
There is another interpretation.
Well, let's The problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
He's
So why
saying there
not-
is a constitutional process by which it can be done under 371.
No, you can't do away with
Okay,
370 sub clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the constitution in
Right,
force.
right.
Can you not say that another order be issued that it can under one saying that all the provisions of the constitution apply and list them all of them and say all of them apply?
You know, the problem there is if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
Mr. Sibal,
It doesn't apply to the other parts.
insofar as clause D is concerned,
Yes.
there are no limitations. If you read it, much of the provisions of the Constitution shall apply in relation to the state subject to such exceptions and modifications as the President may by order specify.
Correct,
This is governed by second proviso,
correct.
provided further that no such which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that
Yes.
government.
Yes.
The treaty of accession, defense and commerce
That's
and so on.
correct, that's correct.
So if-
And the lists involved there.
And the list involved.
Correct,
So suppose if the parliament
yes.
decides to make the entire provisions of the constitution applicable to Jammu and Kashmir.
Yes.
Limitation under clause D.
Yes, there is. That's the point I'm making, Malaz. Because the structure of 370 and in the context of the legislature of Jammu and Kashmir is that the residuary power remains with the state.
Because the distinction is that insofar as those powers
Concurrent
under-
list and instrument of accession are two separate things, but there's no issue there. They can do it, both under 371, no issue.
insofar as instrument of succession, those
Only
entities are
four- only
concerned,
four items.
Their only requirement is consultation.
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 That's correct.
Insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, Mother. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process. Even under 370 sub-article 1. That's the problem. But I see the point that your Lord is making, my Lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my Lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement,
No,
the
but
philosophy of basic structure.
All right, let's not talk of 2023, Madad. In 1950, what was the position? This was the position. That it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament,
no,
how can we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic structure, Madad. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact.
Then what happened?
Unlike other states where Junagadh, he didn't agree, you know, as a political act, you took over Junagadh. He ran away, the Maharaja ran away,
But that, Mr. Sibal, there, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another which forms a part of our constitution, then such a sovereign compact is capable of being overridden
That's all right, Madad. So then we could.
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Madad. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed, consistent with the interpretation of 370. Having taken that position that we need the consent of the Constituent Assembly.
Is this the Constituent Assembly according to you?
Yes,
Yes.
that's right. That's the procedure.
That we've
We're
appreciated
only
that
on that.
submission. Yes, of course, we have appreciated that
We are
submission.
limited only on that.
That the
Large-
process, in other words, your contention is that the process which the government of India followed assumes that the proviso to clause 3 applies,
Yeah.
that this change has to be brought in through a constituent assembly.
Correct.
But this was evidently not the constituent assembly because A, it was the legislative assembly that you have invoked, and two, even that legislative assembly was dissolved and ultimately Parliament was exercising that power in the 356.
Now, the larger question, supposing your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. But we're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the Constitution, if they follow them, maybe, but that may be valid, may not be valid, but I can't answer that question in a vacuum. But my lord is right. What my lord is putting to me, the problem is the residuary power is with the state, and I've shown your lordships, Mullad's provision after provision, right from the Delhi Pact in 1952, that that's the case.
But then what happens to Article 363A?
350?
363A. Because that also earlier the recognition was on the basis of the pact between the various princely states and
different. Those pacts were there, recognition granted to rulers, but either they completely assimilated themselves into the union and be part of a state, or they were taken over. Either Hyderabad or Junagadh.
On the basis of certain agreements between the states and the princely
correct,
states.
But those agreements were different from this agreement. Your lordship is right. If it were that kind of agreement, then your lordships would apply those standards and those principles and those judicial dictums which your lordships applied. We're not on that.
Here your argument is that unless the views of the entire populace of the Jammu and Kashmir are taken into consideration, the abrogation of 370 can't be
yes,
such
that can be done. But that's
then the negotiations were not between the elected body. The negotiations between
because
the princely state and the union.
Correct, and that was accepted. That very thing was accepted by the then constitution makers. So, we can't go into.
So if what was accepted, insofar as the other states are concerned, it could be taken away by 363A.
Correct, but that was not the position as far as Jammu and Kashmir is concerned. I'm not saying anything. I agree with what my lord is putting to me. But how do you change the constitutional structure? There must be some power. You can say that you can do a political act. Today you say, look, forget about all this. We take over Jammu Kashmir. Fine.
363A was done under 368.
Yes, you can do that. But point today is, that's not an issue before you. You're not going to answer an issue which is not, with respect, the greatest respect, which is not before you. You're not going to find a power for them which doesn't exist and which is not followed.
Yes, Mr.
Go back. I understand, the difficulty, and I understand, the fact that at some stage or the other, this had to be, let's put it this way. This had to be done. Let's put it this way. Somebody said this has to be done. But then there must be found a constitutional way of doing it. I'm not saying there are.
It has to be done, I would say, but whether it could be done or not.
No, not could
meet the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. This was a pure political act. And you circumvented the provisions of the Constitution to reach a particular end result, which you always wanted.
That's the second part is that, which you will argue, of course, that the
Yeah.
process by which they followed was.
Yes. Well, that is the issue before you. There's no other issue before you.
According to you, this could have been only done on the recommendation of the Constituent Assembly. Absent a Constituent Assembly, you cannot exercise the power to abrogate.
number one. Number two, in any case, it is they who believed that this could only be done through the Constituent Assembly. Apart from the fact that I say that it could be done, they also believed that it could be done, and they followed that procedure. Now, whether that procedure was right, was wrong, is for your lordships to decide. Whether there is another way to do it is something that they will decide. That's all that I can say. I don't want to make the argument in a hypothetical argument, conjuring up issues that don't arise in this case. And I don't want to give a helping hand as my learned colleague wants to do, because he can do it outside the court.
The lighter side, you said if you had to do it, you would do it a different way.
Maybe. But you can't introduce a bill in Parliament at 11 o'clock, pass a resolution without anybody knowing about it. Of course, those are internal procedures.
You're the Parliament.
I'm not saying anything.
212.
Yeah, so I'm just saying, 11 o'clock,
Or as
nobody
a
knows. Nobody knows.
Larger issue, as a member of Parliament, you will say, don't touch us.
Yes. That's right. So I'm not touching that process either. I'm only saying that this is what, it sort of fits into the argument that this is was a political process carried through certain constitutional means, which unfortunately were not available.
Always a political process, Mr. Sibal. Only question is whether it is within the constitutional means or not.
That's right.
Everything is a political process.
No, I'll tell you how, Manoj, because now let me just go through Coelho and then I'll go back to the list of dates.
Yes.
Volume 3.
You want us to read what now?
Volume 3, Manoj. Page PDF 323. And the fact of the matter is, Malad, apropos what my learned friend said, almost all the laws applicable in the Union of India were applicable in Jammu. As of today, Malad, I have a list, it runs into, pages after pages. Everything has been adopted, apart from the, other than the residuary power. Everything is adopted. Everything. It's like 100 and...
You are referring volume 3?
Yes, volume 3. Volume 3, PDF 323. Case law volume 3. Yes.
No, there is a separate volume for
Case law volume.
Yes, sorry, Miller. Case law volumes. Yes. It's Coelho, Miller.
Coelho and Rameshwar Prasad, they are in one volume.
Yes, leading Coelho, para 54, PDF 323. 323. Running page 776, Mother. Yes. 323, para 54. And remember this, if you use 368, you'll have to have 2/3 present and voting. So you don't use 368 because you don't get 2/3 present and voting. So you go through this procedure. So the question whether 368 could have been used or not is a separate issue. And had that been used, we'd have had another argument here, but it's not an issue here.
Yes, Mr. Sibal. Which
I'm
is
just
the,
telling you
which
the
is the para
hurdles in the
from Coelho that you would like us to see?
Yes, para 54.
At page?
Page 776, Miller's PDF 323.
Page 323.
Yes. The distinction is drawn, my lord has that paragraph? By the author between the making of a constitution by a constituent assembly, which is not subject to restraints by any external authority, as a plenary law-making power and a power to amend the constitution. A derivative power derived from the constitution and subject to the limitations imposed by the constitution. No provision of the constitution framed in exercise of plenary lawmaking power can be ultra vires because there is no touchstone outside the constitution by which the validity of provisions of the constitution can be adjudged. The power for amendment cannot be equated with such power of framing the constitution. The amending power has to be within the constitution and not outside it. Why? Because you're subject to the constraints of the constitution. So you want to amend, you can use 368, but then you have to follow the procedure under 368. But so, for example, if you were to say that you amend the definition and say the provision for consent of the states is not required. Approval of the states is not required. Can you do that? The answer is no. That's a proviso to 368. So if you want to work within the constitution, you have to follow then what the constitution obliges you to do constitutionally. If 368 were available.
All right, apart from Coelho, which is the next?
Yes, next is para 118 of Coelho itself.
PDF?
PDF page 344. We have I'm sorry, para 180. We have earlier noted that the power to, my lords have that?
Para 118.
Yes. We've earlier noted that the power to amend cannot be equated with the power to frame the constitution. The power has no limitations or constraints. It's a primary power, a real plenary power. The latter former power, however, is derived from the former. It has constraints of the document, that is the constitution which creates it. This derivative power can be exercised within the four corners of what has been conferred on the body constituted, namely Parliament. The question before us is not about the power to amend Part 3. As per Keshamnan Bharti, power to amend exists in Parliament, but it is subject to the limitation of the doctrine of basic structure. The fact of validation of laws based on exercise of blanket immunity eliminates Part 3 in entirety. Hence, the rights test as part of the basic structure doctrine has to apply. So, Malats, therefore, we are now left with a Parliament which seeks to amend 370. So therefore, it has to work within the constraints of the Constitution. That's what we're concerned with. We're not concerned with any other interpretation of the Constitution. So now we go back, Malas, to the list of, yes, the Ambedkar statement is volume, yes, document volume 8, PDF page 26. Yes. Volume 8, documents volume 8, PDF page 26. Kamalas, quite frankly,
PDF page?
26. Just two paragraphs, and then I'm done with this issue altogether, Malas. PDF page 26. Documents volume 8.
Eight.
Your lordship has it? May I read it, Manoj?
Page?
Page 26, paragraph starting the provisions relating to amendment of the Constitution. My Lord Justice Surikant has it?
Yes.
My Lord Justice Kaul has it?
Yes, yeah, fine.
The provisions relating to amendment of the Constitution have come in for a virulent attack at the hands of the critics of the draft Constitution. It is said that the provisions contained in the draft make amendment difficult. It is proposed that the Constitution should be amendable by a simple majority, at least for some years. The argument is subtle and ingenious. It is said that this Constituent Assembly is not elected on adult suffrage. Well, I've read this part of it I've read.
We actually read it from just Jagannath Reddy.
Let's leave that. Come to the next paragraph.
Sorry, again.
What is said to be the absurdity? That paragraph, next paragraph.
Yes.
What is said to be the absurdity of the amending provision is founded upon a misconception of the position of the Constituent Assembly and of the future Parliament elected under the Constitution. The Constituent Assembly, in making a Constitution, well, that also I've read. So this is the exact.
There's only one part in Dr. Ambedkar's statement which is very prescient. Dr. Ambedkar postulates that a future Constituent Assembly may be a future Parliament itself.
Yes.
Says the future Parliament, if it met as a Constituent Assembly,
Yes.
its members will be acting as partisans, seeking to carry out amendments to the Constitution
Yes.
to facilitate the passing of party measures which they failed to get through Parliament by reason of some article of the Constitution, which has acted an obstacle in their way.
This is
That
the
is
precise
difference between
argument.
the Constituent Assembly and the future Parliament.
So this is the precise argument I'm making, is what Dr. Ambedkar said. That it is the party's partisan political measures that are carried through in the process in the form of legislation or otherwise, which can't be done as far as which will be constrained by the provisions of the Constitution, but the Constituent Assembly doesn't have any such fetters.
Yes.
So, Mullahs, I'm done with this whole argument, Mullahs. So now let's go back to the list of dates and how all this happened, the other issues. No. Now compilation.
We go to
In my written submission.
your written submissions, volume
Written
2.
submissions, volume 2. And kindly come
Page
to
48.
the page 47. Yeah. Yes, where is that? Yes.
These are
Now,
list of dates.
List of dates, kindly come to
Volume
PDF
written
47,
submissions.
item 57.
Submissions. Yes.
Item 57, PDF 47 in my list of dates, volume 2 of the written submissions. Well, that's 20th of June, 2018. Section 92.
That we saw, Mr. Sibal.
Yeah.
That we saw, you read out section 9.
That's right. No, but what's important is the date. On the 19th of June, a political party in coalition with another party which was in government withdrew support.
That is not in a list of dates.
Yes, just kindly note that. It's in the proclamation.
19th of June 2018.
Yes, well, it's BJP withdrew support from PDF.
This is
PDP.
Before the serial number 57, no?
Yes, yes. It's in the document, but I just wanted to. It's the proclamation. Let's see then.
Yes, Mr. Sibal.
Now, let's, so he issued, the governor on the next day issues a proclamation, which is also quite curious.
That we find at top of page
That
48.
your lordships may look at Millard's PDF page 85, volume 3, the proclamation itself.
Anything turns on it? I mean, in the sense to read it. I mean, you've paraphrased it, I guess.
Yes, I have paraphrased it.
Is there any particular
Nothing.
sense?
The provision
Not
permitted the
necessary.
governor by proclamation to assume to himself all the powers and functions of the government of the state. Such a proclamation in one terms of 92.5 required concurrence of the president, and under 92.3 would cease to operate within 6 months, which I've already mentioned to your lordship. We need not go into.
This is the power corresponding to 356, which is vested in the governor.
That's right. That's right. But here it's vested in the
The governor.
governor, independent of the council of
Of the
ministers,
council.
which I mentioned to your lords. It's a very, very unique power. And the council of ministers was suspended in the process. Malas, he didn't even wait for a day. I mean, it's normally speaking, what would happen, Malas? A governor would wait for other political affiliations to take place to form a government.
That's also part of political process.
I'm sorry?
That's also part of political process.
That's precisely what I'm saying, Malas. But why do you think I've been saying this? Why would a governor do this on the next day, Malas?
Yes, then what happened?
Well, then, well, so he does this, so 6 months were to expire. Then, well, there is some controversy, and I just tell your lordships orally that controversy is. According to the PDP, and I think somebody else will argue that, I'm not arguing. According to the PDP, they send a fax to Srinagar that they have the support of the National Conference and they are willing to form the government. The governor says he never received the fax, because he says that he was in Jammu and the fax was sent to Srinagar. So Malas, on the 21st of November, the next day, he dissolved the assembly. Yeah, on 21st November.
The facts of some
Fax is also
constitution
sent on
benches have a
21st.
sense of deja vu, you know.
Fax is sent on 21st, he dissolves it on 21st. The fax hasn't reached him. Fax was sent.
It's almost on the annual of the period expiring.
No, that expired on 3rd of January, 19th of December.
19th, so about a month short of
Yes,
that.
yes, month short, Malas.
This is
Because-
not under challenge anymore.
No, no, I'm not,
that's
I
not-
myself said so. I myself said that that is an issue which.
So he dissolves the legislative
He
assembly.
dissolved the legislature. Now, Malas, you can't dissolve without the council of ministers. 36, 38 and 92 are his only powers. He has already suspended the council of ministers. He dissolves it,
Without the aid and advice.
nothing. Why do you think I've been saying continuously that this is a pure political act? The governor and the government were acting in tandem. They wanted to get rid of 370. Toss it out. Why would any governor do that? Why would the governor on 20th of June, after withdrawal of support on 19th of June, suspend the assembly? Don't allow any political affiliation and parties to take place so that a new government can be formed.
Which is the power of dissolution under the constitution, just for the cross.
Yes, 53. Section 53 of the Constitution of Jammu and Kashmir gives that power of dissolution, not part of the exception given to the governor with reference to his powers that he can exercise without the aid of the Council of Ministers.
Yeah, because section 35 refers to 36, 38 and 92.
36, 38 and 92. The process, according to me, when you're interpreting constitutional provisions, is as important as the substance. Because it's a constitutional process.
That's what another Coelho says, but this time it's Paulo Coelho in The Alchemist.
That's right. Then, Milad, on the 19th of December, the proclamation of governor's rule expired. A proclamation under 356 promulgating president's rule in the state of Jammu and Kashmir was issued on 19th December. So then came president's rule. So on 3rd of January, want to show the proclamation? Well, it's better to see the proclamation, volume 3, PDF 92. Volume 3 of documents, PDF 92.
You want us to look at this, Mr. Simal?
PDF?
So you want to?
Yes, I do. Let's see that, Malad. It's important. Because that's a very important provision. It has huge implications as to what happened later. My lords have PDF 92.
PDF?
92, Malad. Volume 3 of the document. Justice Gawai, Justice Kaul.
Yes.
Justice Surikant.
Yes, it seems good.
Yes.
The following proclamation by the President is published. I, so and so, have received a report from the Governor of the state of Jammu and Kashmir, and after considering the report and other information received by me. Well, it's all Governor's rule. Kindly see, Malad. It's all Governor's rule from 20th of June right up to this date. There's no Council of Ministers in place. There's no government in place. But he sends a report that the government cannot be carried out. Where is the basis for any of that? There are no negotiations. There are no communications. So he says, I am satisfied that a situation has arisen in which the government of the state cannot be carried on. Government of the state, but the government of the state was carried on by the governor. In accordance with the provisions of the Constitution of India as applicable to the state and of the Constitution of Jammu and Kashmir. Now, in exercise of the powers conferred by Article 356 and of all other powers enabling me in that behalf, I hereby proclaim. Kindly come to C. A, assume to myself as President all the functions of the government of the state and all powers vested in or exercisable by the governor in that state under the Constitution and the state constitution. Declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. Now, this is important, Mullah. Therefore, Parliament will be exercising the powers of the state legislature. And the state legislature under Mullad's 147, you can't move a bill. Which is what Ambedkar said, which is what Keshav Nand said, that you can't do this. You have to be confined to your powers and responsibilities under the Constitution under which you're acting. So, declare the legislature of that state shall be exercisable by or under the authority of Parliament, make the following incidental and consequential provisions which appear to me to be necessary or desirable for giving effect to the objects of the proclamation, in exercise of the functions and powers assumed to myself by virtue of Clause A of this proclamation, as aforesaid, it should be lawful for me as President of India to act to such extent as I think fit through the governor of the said state, the operation of the following provisions. Now, this is very important, of the Constitution and of the state constitution are hereby suspended. Under what power? So much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so much of Clause 2 of Article 151 of the Constitution as relates to laying before the legislature of the state of the report submitted by the governor, by the Comptroller and Auditor General. Now, what they did was they took away the proviso to Article 3. Under what power? You can't amend the Constitution in virtue of your power under 356. Now, let's see what the proviso to Article 3 of the Constitution says, Melissa. Kindly have a look. Kindly give it. Volume 1. Constitution, Volume 1. Documents, Volume 1. PDF page 186. Sorry. 65? PDF page 65. Yes. 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 One second, hold on. So PDF page 65. This is an amazing piece of handiwork. It's a mosaic of illegalities. Attracted enough to be junked. I don't understand how this always happens. There must have been great constitutional advisors, Mulats, who would have thought of this very complicated handiwork, which found itself in our Constitution. Bloody hell. Totally, so I wrote it now.
Right, right.
Politics. So Article 3, Malak, document volume.
So they delete effectively the proviso to Article 3. But Mr. Sabal, at the end of it all, I mean, of course, this has the optics about the way it was done. But there's no challenge to anything that was done. All this is not under challenge here.
No, Maharaj, once you are challenging the emergency, Maharaj, the declaration of 356 is challenged. Maharaj, just look at
What is
it.
the frame of the petitions? Do we have a challenge to
Yes,
the
we have one challenge. But Maharaj, quite apart from that, you're looking at Maharaj, it's in
Yes.
grade 370, Maharaj. I mean, it's not. we-
All right, we just see what the frame of the challenge. If you can just ask one of the juniors to make that little tabulation
I do
for
that.
us.
But apart from that, Maharaj, this is now before you.
Yes.
In all its various
Nuances
parts, in
and-
a sense.
Yes, of course.
Now the question is, Maharaj, what is the power? And that's the other thing. What is the power under 356? The quintessential object of 356 is to restore democracy. You take over because a government cannot be run in accordance with the provisions of the Constitution for a temporary period for the restoration of democracy. You don't use 356 for its decimation. You can't amend the provisions of the Constitution under 356. Of 356. We'll give it on Tuesday. We have to show the Constituent Assembly.
Require ratification by the state legislatures. Now, suppose a particular state, the legislature, the power has been exercised under 356 and the president assumes the powers of the legislature, the executive. Can a ratification be done under 356 in relation to that particular state legislature?
No, Maharaj. No, because he's exercising powers as a state legislature, Maharaj, in this sense. There is no question of ratification.
Not in the J&K case. I'm
Yes.
just theoretically, I'm saying, can a
Generally, what is my lord is putting to?
some constitutional amendments under the proviso
Yes.
require a ratification.
That's right. That's right.
Now, for the purpose of computing the majority, computing the strength required for ratification,
Yeah.
can the center fall back upon the exercise of the 356 power? Say that, look, we have ratified it because we were exercising the power under 356.
Tough question.
Has
What
never
my lord is
happened, but
putting to me is that if Jammu and Kashmir, in a 368 situation, if Jammu and Kashmir were to ratify it, then Parliament can exercise that power.
Suppose any Indian state,
No, Malad.
you require a certain number of states.
Provided, Malad, the 356 is imposed there, not otherwise.
But if 356
Yeah.
is imposed, then can that power to
That's-
ratify the
that's a tough
amendment be
question.
exercised?
That's a tough question.
Even that is a little.
Yeah, it's a tough, I can't answer it.
yeah,
right
even
away.
I-
I'll have to think
just-
more about it. Because the ratification is of the state, therefore there are two separate constitutional authorities. One Parliament passing the law and
And then the
another
state.
authority ratifying it. You can't take the position, that's like, it takes two hands to clap. It's the same analogy. Therefore, you can't exercise that power yourself because that's power constitutionally is provided for in another institution, in another constitutional body.
Now here the proclamation comes under 356.
That's right.
After that, what is done then?
Then, Malas, they amend section, Article 3.
We saw that.
Yes. But Malas, kindly see, just read Article 3 with me for a minute. Formation of new states, alteration of areas, boundaries, or names of existing states.
Amendment to Article 3 required as part of this whole process?
Because they wanted to get rid of this proviso, Malas. Otherwise, they wouldn't have been able to. Yes. Because then you have to do the Reorganization Act.
Or the reorganization?
Yeah, that required.
Converting the state into a
That's
UT.
right, that's right. That's how this had to be done earlier. Second proviso is not your lordship's document, that has been the other document. The second proviso relates to Malaj as applicable to the state of Jammu and Kashmir. Kindly have a look at that. Kindly just show that document.
Document volume 1.
Volume 1.
Of the order passed,
Yes. There the proviso is there.
there the proviso was.
That's correct.
That proviso is deleted.
That's correct.
Which is that proviso?
Which requires, I'm going to show that to your lordship. PDF page 65, document volume 1.
That was,
Yes.
that must be pursuant to the presidential order.
Correct, absolutely right.
So the presidential order was not, was the presidential order amended? No.
No. That's interesting.
It has been superseded, my lord.
It deals with the second proviso. You can't even introduce the bill, forget about anything else.
Or only one second provision.
Second part of the first proviso and the second proviso.
Where do we get this document? Actually, it's document number, document compilation.
Documents volume 1, PDF 65.
65.
Constitution of India as applicable to the state of Jammu and Kashmir.
At page?
PDF 65, running page, Malaz, is 65, also 65.
That's the Constitution of India is applicable to the state of Jammu and
That's
Kashmir.
where the only place where the pages of the Constitution of India and the Constitution as applicable synchronize, Malaz. The rest is.
I interestingly read the note below. It says when secular was inserted into the Constitution,
Yeah.
it was never inserted here.
Never inserted, okay.
Just see the note below
I
it.
got it, I got
Note 1, you got it?
Yes, I got it at the bottom, yes. Socialist secular.
Let's agree.
But see, Malaz, what they've done.
Where is the proviso?
Proviso, Malaz, at page 66, next page.
Second proviso.
Let's read the whole, Malaz, it'll be better
Yes.
if we read the whole, if you don't mind.
Yes.
Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may by law form a new state by separation of territory from any state. Well, this is also be important when you deal with the Reorganization Act. You might as well read the whole article. Parliament may by law form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless, where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon, which within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed is expired. That's why, Malas, when the views of states was taken, Malas, they said, no, you haven't referred it. We said, only need to take your views. We don't have to take your consent or your concurrence. So we may not agree. Even if you express your views that it should not be done, we're not bound by it, which is the correct constitutional provision. Then the second proviso, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir, or altering the name or boundary of that state, shall be introduced in Parliament without the consent of the legislature of that state. So you can't even introduce it. Here by 356, you do away with it.
They have created a UT. Otherwise, they have not altered the territory, have they?
No, they haven't.
No.
Ladakh is not part of the state anymore.
That's what they carved out a UT and made another UT, which they say.
Yes, carved out a UT saying that this will become a state, and the other UT will remain a UT.
So carving out a UT is permissible, no?
But boundaries are.
Not from a state, I'm sorry. You can't
Boundaries
create
are altered.
a whole state as well.
Boundaries are also.
Yes,
altered.
boundaries are also altered.
To that extent, yes.
So, Malas, this is all. And Malas, there is and I'm going to take your lordships to the Constitutional Assembly debates on this. Just presently, I'll do that.
And for J&K, consent is required.
Yes.
Not just the views, but the consent. Other states.
No, Malas, you require the consent before you introduce it.
Right.
Yes.
Other states, it's only the views have to be taken, but for J&K, the consent is required
Before you
to introduce the bill.
Yes. I'm sorry.
Okay. Is it mentioned only in 1954 constitutional order, or is it incorporated in Article 3 also?
It's mentioned in the 54 order and incorporated in Article 3 before the 54 order.
If
Yes.
it is incorporated,
Yes.
that would amount to amendment of the constitution. Then was it followed as per Article 368?
Not in the Indian Constitution, Malas. It's only in
Article
this Constitution.
This proviso, second proviso,
Yes,
you are reading.
yes.
Now we are reading it on the presumption or assuming that it's a part of Article 3 of the Indian Constitution. Second proviso.
No, it's a modification of Article 3. As applicable. As applicable only.
So it is only incorporated in the 1954 order,
As
not formally inserted in Article 3 of the Indian Constitution as a second proviso.
Correct. Absolutely right, what my lord is putting to me. Absolutely.
They suspended the operation of
They
it.
suspended the operation. How do you get that power under 356? That's not the object of the proclamation.
Deleted, suspended.
Then the exercise.
That assembly can't exercise that power unless to suspend.
On behalf of the assembly.
Yes, they can't do that also. A bill cannot be introduced without the consent. Assembly is not in session. There is no assembly, it has been dissolved. So where do you get the consent of the assembly? So the governor becomes the assembly, then the assembly becomes parliament, and then parliament gives consent. On behalf of an assembly that doesn't exist.
Mr. Sibal, what was the procedure followed when different orders were issued under those constitution, right? Like those about 18 orders, constitution orders,
Yeah.
1952 up
Yes,
to.
all minutes with concurrence. With reply, with
What was the procedure followed?
procedure
Was it through parliament process or through by the president only?
No, it's not through a parliament process, it's through a presidential notification after taking the consent, concurrence or consultation. That's right. So that's how it's made applicable, through a presidential order. No. So it's 356 and exercising powers under 356. It's a Well, in this context, before I go back to 356, it's better to your lordships looks at the Constituent Assembly debate on this. On this Article 3 and why this was Volume 8. PDF page 289. Which Dr. Ambedkar Maharaj at 289 says, "Sir, I move." Yes. There's sir, I move that for the existing proviso to Article 3, the following proviso be substituted. Provided that no bill for the purpose shall be introduced in either House of Parliament except in the recommendation of the President, and unless where the proposal contained in the bill affects the boundaries or name of any state or states for the time being specified in Part 1 of the first schedule, the views of the legislature of the state, or as the case may be, of each of respect to the provisions thereof have been as contained by the President and the states, both with respect to the proposal to introduce the bill and with respect to the provision thereof has been ascertained by the President, and where such proposal affects the boundaries or name of any state of states or states for the time being specified in Part 3 of the first schedule, the previous consent of the state, or as the case may be, of each of the states to the proposal has been obtained. Mr. Vice President, if one were to compare the amended proviso with the original proviso, as it was set out in the draft constitution, members will see that the new amendment introduces two changes. One is this: in the original draft, the power to introduce the bill was given exclusively to the Government of India. No private member of Parliament had the power under the original draft to propose any legislation of this sort, attention of the drafting committee was drawn to the fact that this was a somewhat severe and unnecessary curtailment of the right of the members of parliament to move any motion they liked, and in which they felt concerned. Consequently, we deleted this provision, giving the power exclusively to the Government of India, and gave it to the President, and stated that any such bill, whether it was brought by the Government of India or by any private member, should have the recommendation of the President. That is one change. The second change, which is more important, is this. Under the original Article 3, the power of the Government of India to introduce legislation was restricted by two conditions, which are mentioned in A1 and 2I. The conditions that were that there must be, before the initiation of any action, representation made to the President by a majority of the representatives of the territory in the legislature of the state, or a resolution in that behalf passed by the legislature of any state, whose boundaries or name will be affected by the proposal contained in the bill. Here again, it was represented that there might be a small minority which felt very strongly that its position will not be safeguarded unless the boundary of the state were changed, and that particular minority was permitted to join their brothers in the other state, and consequently, if these brothers remained there, action would be completely paralyzed. Consequently, we propose now in the amended draft to delete 1 and 2. This is important. To delete 1 and 2 of A and also B of the original draft. These have been split into two parts, A and B. A deals with reorganization of territory insofar as it affects the states in Part 1. That is the Dominion states. Part 1, that is to say provinces, and of the new amendment relates to what are called Indian states. The main difference between the new clause A and B of any amendment is this. In the case of A, that is to say, reorganization of territories of states falling in Part 1, all that is necessary is consultation. Consent is not required. All that the President is called upon to do is to be satisfied before making the recommendation that their wishes have been consulted. With regard to B, the provision is that there shall be consent. The distinction, as I said, is based upon the fact that as far as we are at present concerned, the position of the provinces is different from the position of the states. The states are sovereign states and the provinces are not sovereign states. Consequently, the government need not be bound to require the consent of the provinces to change their boundaries, while in the case of the Indian states, it's appropriate in view of the fact that sovereignty remains with them that their consent should be obtained. As regards the amendment moved by Professor Shah, I do not see much difference between my amendment as contained in subclause A of the new proviso and this and his. He says that the discussion shall be initiated in the states. My subclause A of the proviso also provides that the states shall be consulted. I have not the least doubt about it that the method of consulting which the President will adopt will be to ask either the Prime Minister or the Governor to table a resolution which may be discussed in the particular state legislature, which may be affected, so that ultimately the initiation will be the local legislature and not by the Parliament at all. I therefore submit the amendment of Professor Shah is unnecessary. Now, this was adopted. So the views of the people of the state were to be taken. So the second proviso, Malaz, when it came in, they said that this will not apply to Jammu and Kashmir. They needed consent. And so therefore no bill could be introduced. This is consistent with all of the provisions, including 370. Including the powers of concurrence, Malaz, with respect to the concurrent list in the concurrent list of the Constitution as applicable. So this is a consistent thread throughout, which is accepted by the Constitution makers. So now, Malad, if you now go to 356, document volume 3, no, this is very, PDF page 92, I'll read further, Malad. So they suspended this.
Document volume 3.
Yes, Malad, volume 3, PDF page 92. That's the proclamation. So when everybody was all states were integrated into the union, that means you didn't need any consent. But since this was not integrated, Jammu and Kashmir, therefore the second proviso was provided. And Millers, your lordships will see that the whereas clause says provisions of the Constitution of India as applicable to that state and of the Constitution of Jammu and Kashmir. Both. And now, Millers, so much as the first proviso to Article 3 as relates to the reference to the President of the legislature of the state, and the second proviso to that article, so much of clause 2 that we don't need to read that. Then, Millers, kindly item 3 of the proclamation. Any reference in the Constitution and the state constitution to the governor shall, in relation to the said state, be construed as reference to the president. And any reference in the Constitution and the state constitution to the legislature of the state or the houses thereof shall, insofar as it relates to the functions and powers thereof, be construed unless the context otherwise requires as a reference to Parliament. So governor functions to Parliament, legislature functions to Parliament. So it's all Miller's. The power is concentrated in Parliament to do what it likes. And in particular, the reference to Section 91 of the state constitution to the governor and to the legislature of the state or the houses thereof shall be construed as references to the president and to Parliament, or to the houses thereof respectively. So, Millers, you lose the link between the center and the state altogether. You absorb the powers of the state with yourself as the executive, as well as Parliament as the legislature. And you decide without reference to any other institution. Governor means president, legislature means Parliament. So you can do what you like. And so you give yourself consent. You don't have to seek consent. And the people who gave themselves this constitution are left out of the process altogether. This is essentially, according to me, a breakdown of the constitutional structure that was engrafted in the Constitution. It's a complete breakdown. By inhering in yourself as the union the power of the state, executive power of the state, and by Parliament, the legislative power of the legislature. So you do away with any representative form of government, do away with institutions, and make it irreversible.
Yes.
Then let's go back now to the list of dates. PDF 48. Written submissions compilation volume 2, PDF 48. So I've done with the proclamation 19/12/2018. So item 60. My lords had that. A resolution approving this proclamation issued by the President on 19/12/2018 was passed in the Lok Sabha on 28/12 and the Rajya Sabha on 3rd of January. Then, brothers, we don't have to read this. Jammu Kashmir peoples, we're not concerned. Kindly come to 60, item 65, PDF, page 50. So at item 65, you will find on the 3rd of July, 2019, the President's proclamation was in terms of Article 356(4) to expire on 2nd of July. 6 months, mothers. Because from January 3, 2019, it would be July 3. So it was to expire on 2nd July. Consequently, President's rule in J&K was extended for a further period of 6 months with effect from 3rd of July till the 28th of June 2019 and Rajya Sabha on 1st of July. Then leave all this. Then 72, page 53, PDF page 53. This is that 11 a.m. order on the 5th of August 2019.
We'll break here. Mr. 3 minutes short. We are going to the 11 a.m. order now. We'll continue with this on
We'll
Tuesday.
wait for 11 a.m. the next day. I'm deeply obliged. We appreciate your lordship's patience, mothers.
We'll come back on Tuesday.
Yes.
Tuesday, no?
Lordship, on matter, the High Court has pronounced the order that my lord had remanded to them. We filed an SLP against that. We sent the email as per the protocol, requesting for a listing. Lordship, because they may not proceed with the survey.
I'll look at the email right away.
Grateful, Lordship. Great.